Required signage to post at your establishment. Pregnancy warning signs. Studies have shown that if a woman consumes alcohol while pregnant, it can cause fetal alcohol birth defects as well as other complications. An off-sale retailer or an on-sale retailer shall post one or more signs in the premises where spirituous liquor is sold that clearly warns pregnant women of the dangers of consuming spirituous liquor during pregnancy. The sign must contain the words, "Warning, consuming alcoholic beverages, including distilled spirits, beer, coolers, and wine during pregnancy can cause birth defects." An on-sale retailer must post a sign within 20 feet of each register where sales of spirituous liquor are made or behind the bar from which spirituous liquor is served. A hotel-motel licensee must post one sign on the inside of the front door of each guest room that contains a minibar or in each guest room where spirituous liquor is available through room service. They must also post the pregnancy warning sign no smaller than 1 by 2 inches in areas that are conspicuous so the warning can be read. A retail licensee that uses a mobile service device for the sale of spirituous liquor shall display the sign required on that mobile service device. Each off-sale licensee shall conspicuously post the sign required by this section where a customer obtains the spirituous liquor. Your establishment can obtain these signs from the DLLC at no cost. Postage of liquor license. All retail licensees must display the liquor license in a conspicuous public area of the licensed premises that is readily accessible for inspection by any peace officer, distributor, wholesaler, or member of the public. Firearm signs. It is illegal for a person to be on or in a licensed premises consuming spirituous liquor while carrying a firearm. This does not include peace officers working on assignment, as well as a retired peace officer as defined in Section 38-1113, or an honorably retired law enforcement officer who has been issued a certificate of firearms proficiency pursuant to Sections 13-3112, subsection T. Firearms are not allowed in an on-sale licensed premises unless it is the licensee, an employee who has the owner's permission, a peace officer, or a person who has a concealed weapons permit, as well as a retired peace officer as defined in Section 38-1113, or an honorably retired law enforcement officer who has been issued a certificate of firearms proficiency pursuant to Sections 13-3112, subsection T. But if the licensee has posted the sign that prohibits firearms in their establishment, then no person may enter the premises with a firearm, even if they have a concealed weapons permit. If a customer enters the premises with a firearm and they see the sign, they will have to leave with the firearm and return when they are not carrying the firearm. What can happen to you as an individual person if you receive a Title IV violation? The officer can issue a criminal citation for the offense as it referenced in ARS 4-246. Those can also be administrative violations as well, depending on who the violation is against. Officers can use discretion whether or not to issue a criminal citation when it comes to violations of Title IV. All administrative code, the director's rules, can only be administrative violations against the licensee. A person violating any provision of this title is guilty of a Class II misdemeanor unless another classification is prescribed. A person violating Section 4-244, Paragraph 9, 14, 34, 42, or 44 is guilty of a Class I misdemeanor. A person violating Sections 4-229, subsection B, or 4-244, paragraph 31, is guilty of a Class III misdemeanor. In addition to any other penalty prescribed by law, the court may suspend the privileges to drive of a person under 18 years of age for a period of up to 180 days on receiving the record of the person's first conviction for a violation of Section 4-244, paragraph 9. In addition to any other penalty prescribed by law, a person who is convicted of a violation of Section 4-244, paragraph 42, shall pay a fine of not less than $500. In addition to any other penalty prescribed by law, a person who is convicted of a violation of Section 4-241, subsection L, M, or N, shall pay a fine of not less than $250. Also, since minors consuming, possessing, or purchasing alcohol is strictly forbidden, and furnishing spirituous liquor to a person who is obviously intoxicated is also strictly forbidden, you need to know that. If you are legal drinking age and knowingly allow a gathering of 2 or more persons who are under the legal drinking age to be in possession of or consume any alcoholic beverages on your premises, ARS 4-241 H1, you sell or furnish alcoholic beverages to a person under the legal drinking age, You receive or procure alcoholic beverages with the intent of giving or selling it to a person under the legal drinking age. ARS 4-241G. You serve, sell, or furnish alcoholic beverages to a disorderly or obviously intoxicated person, which is ARS 4-24414. The penalties you face. All of these violations are a Class 1 misdemeanor. If you're convicted of a Class 1 misdemeanor, the maximum penalty is a fine of $2,500 and 6 months in jail. If it is your first offense, you'll probably face a fine of several $100s. However, if you're convicted or plead guilty, you will have a criminal conviction on your record for the rest of your life. It is a violation of the law if you are under the legal drinking age and you buy, receive, have in your possession, or consume alcoholic beverages, which is ARS 4-244-9, Class 1 misdemeanor. You are under the legal drinking age and solicit another person to purchase, sell, give, serve, or furnish you alcoholic beverages, which comes from ARS 4-241D, Class 3 misdemeanor. The penalties you may face. The maximum penalty for a Class 3 misdemeanor is a fine of $500 and 30 days in jail. The maximum penalty for Class 1 misdemeanor is a fine of $2,500 and 6 months in jail. If you're a first-time offender, the penalty will probably be a fine only, but you will have a criminal conviction on your record for the rest of your life. Fake IDs. You are violating the law if you misrepresent your age by way of false identification with the intent to induce a person to sell, serve, give, or furnish you with alcoholic beverages. You use false identification or identification of the person to gain access to a licensed establishment. You give information you know to be false to an employee of the Motor Vehicle Division in order to obtain a false ID. You knowingly give false information to a law enforcement officer. You knowingly take the name, birth date, or social security number of another person without the consent of that person with the intent to obtain or use the other person's identity for any unlawful purpose, such as obtaining a false ID. The penalty you may face for that is using false identification to get into a licensed establishment and giving false information to a police officer are both Class 1 misdemeanors. Misrepresenting your age to obtain alcoholic beverages and giving false information to the Motor Vehicle Division are Class 2 misdemeanors, which carry maximum fines of $750 and a jail term of 4 months. If you use false ID, either a driver's license or identification card, to obtain alcohol or to gain entrance to a licensed establishment, your driver's license or identification card will be suspended for 6 months for first conviction. If you don't have a driver's license, you will not be able to apply for one for 6 months. Using another person's identity to obtain a false ID is a Class 5 felony, which has a maximum fine of $150,000 and a presumptive prison sentence of 1.5 years. Now, what can happen to your establishment? Remember, you're an agent of your premises. If you get cited, your establishment can get cited. According to the DLLC website, in a 30-day period, 58 citations were adjudicated. The citations varied from failure to follow the identification procedure prescribed by statutes, to sell, give, furnish underage person with alcohol to intoxicated on premises for 30 minutes. The fines range from a warning letter up to $10,000. This concludes Module 5. Let's do a little recap. In this module, you learned about Arizona state liquor laws. You should now be familiar with the importance of compliance to laws and rules and be familiar with the laws regarding inspection of premises, retaining business records, the purchase of alcohol for resale, storage of alcohol, sampling alcohol, legal hours of alcohol sales and service, the legal age to sell or serve alcohol, the various liquor licenses, required signage, and Title Forward violations. You may now take the Module 5 quiz.